Thank you, Daniel. Good afternoon. Good afternoon. It was good. So, welcome back from the lunch break. Apologies for the slides, which is here. So I will just be as brief as possible so that I don't take too much time, so that we can go to other events and not to keep us for too long here. But I will briefly be, in a sense, narrowing down a bit now on some of the things that we have discussed in the morning, and specifically now looking at how CSOs can improve the effectiveness of African human rights bodies. So if you notice from all of the presentation about the court, about the commission, and about the committee, you would see that there is this issue, and I think I can't remember the person. Someone here was asking Prof. France in the morning about, well, what do we do when states don't want to comply with these things, or are states even interested in complying with these issues? And I think you are the one who asked that question. So yeah, it's a whole problem on its own, and it's something that is it's a dedicated area of research in a sense. So what I will do is to just start with conceptual clarifications so that you can just follow how I use the terminologies. So in the morning, you heard about the African Commission on Human and People's Rights, you heard about the African Court on Human and People's Rights, and you heard about the African Children's Committee. So now, for the purposes of this conversation, because I am not focusing on a specific body per se, we are looking at all of the bodies as a whole. So I will refer to them as African human rights bodies. So when I say African human rights bodies now, these are the dedicated supervisory mechanisms. And that would be the African Commission, the Court, and the Court. So that is how it should be understood in the context of this presentation. And one other word that I would use is the jurisprudence of the African human rights bodies. Now, the jurisprudence of the African human rights bodies, I'm using it because when you see from the morning presentation, they talk about the individual complaint. Now, what is the output of the individual complaint? It's a decision, it's a judgment. But beyond that, the African human rights bodies have other outputs. So when you submit, when states submit the state reports, they get concluding observations. Those are recommendations. The African human rights bodies, they issue general comments, they issue resolutions, and these are all outputs of these bodies. So for purposes of this presentation, I will simply use that umbrella word and call them jurisprudence of the African human rights bodies. Of course, as I go into my conversation, into my presentation, I will be specific where I need to be specific, if it's a decision, if it's a concluding observation. Now, there are three things that we need to understand from this perspective. The word implementation, the word compliance, and the word follow-up. So they are all English words. So maybe I can just start by saying, what is our understanding of implementation? So you asked the question the other time. If I ask you, what does implementation mean? What would you say? Execute what have been discussed. To execute what has been discussed. What does compliance mean? Don't look at the screen. Okay, why is thinking about it? I see you are excited. What does compliance? Sorry, I missed your name. What is your name? What does compliance mean? I mean, it's an English word. Just tell me how you understand it.
To follow through with what is being required, comply with the specification of it.
What does compliance mean? To comply? Okay. No, I don't accept that. Yeah, okay, I see two hands. Wow, that's interesting. Okay, I see your hand first, but in the interest of gender representation, so I'll move to the man. Okay.
I would say it's to
carry out.
No, I don't want them to cheat.
Exactly, don't put it on the screen. Yes.
carry out tasks as prescribed in your policies, maybe. That is comply.
Okay. And what does follow up mean? What does the word follow up mean? Not you now. I'm asking Samuel.
It depends on the text of the follow-up. It could be a scenario where the body that has as the recommendation, the resolution, or the ruling now says to how the actual action has been executed upon. Basically, to see if the prescripts have been followed according to the manner in which they've been set.
Okay, that's not bad. That's really out there. But I see you wanted to say something. Are you covered?
To check on progress, to see where the process or whatever the decision or the implementation has progressed.
That's interesting. Brilliant participants. Everyone knows these things already. Maybe I can just Pamela, you can just move the slide. So now you see implementation. I mean, you are all correct, and now I'm just bringing it back to the context of the African Human Rights Body. It's a dynamic process in which you take steps, you take measures to comply with the jurisprudence of the African Human Rights Bodies. Now remember the word jurisprudence, I remember the word African Human Rights Body. So it's a collective word now. So that is what implementation means in this context. Now compliance, it's not far from what you have all said. It's just that for purposes of this kind of conversation, when we say compliance, compliance is like an output, it's the outcome of implementation. So if you say the government of South Africa should put tea on everybody, doing that. And when we have tea on the table, then we say the government of South Africa has complied with that recommendation. So you see, that is how it works. And now follow up, like she said, and that's been said, in this context now is the process now that everyone that is involved in this whole situation that we take to look at, we're saying, okay, what is happening? They say we should have tea on the table. It's 10 minutes. We've not seen our tea. It's 10 minutes. The presenter has not come in. What is happening? That is you following up, because there's supposed to be a particular outcome and you did not see it, and then you're saying what is going on. So this is what follow-up would mean in this context. Now, quickly, we talk about the challenges to the effectiveness of African human rights bodies. And you've had advocates Nakula speak about the commission, you've had all of these things. But does it mean that everything is all good and fine for these bodies? Actually not. And the key issue here that the bodies have historically had since the establishment of all of this body is the problem of implementation and compliance within the context in which we have all understood it now. Now, in the morning, Prof. Franz said the only country that is yet the or African countries, and I mean that is like wide acceptance of the African Human Rights Charter. And there have been, well over 10-something states that are ratified to protocol. So in a sense, you see that, you would say African states are really embracing human rights, they ratified this treaty and all of that. But then you find out that the same level of commitment, that desire is not present when you look at how they implement now the obligations from those treaties. It's one thing to say we have ratified and we're done with that, but of course the treaties require you to do A, B, C, D. And now, specifically in the implementation of the jurisprudence of African human rights bodies. Now, I'm just going to put this in context for you. You see, in the 2021 report, so the African Court had in 2021 the conference on implementation and impact of the decisions of the African Court. You see how problematic it was. The African Court had to dedicate a conference specifically on the implementation and impact of its decision. Now, this is the court's record by itself. Imagine when someone is assessing themselves. But you see, the level of full compliance with the court's judgment stood at only 7%. At this time, the court has issued well over 165 judgments and rulings. Now, if I send my kid to school and out of 100%, my kid comes back with 7%, I don't know about you, or what would you think about that kid? You can clearly see that there is a lot of problem. And Here, I will not go too much into this because you see the word partial compliance and you see non-compliance. So these are very technical terms that you use when you break down. Court says do 1, 2, 3, 4. If the state has done only one, then we say maybe partial compliance because they have 2, 3 outstanding. But anyways, the bottom line is in terms of full compliance, it stands at 17%. And even for partial compliance, it starts at 18%. And also, next slide please. The African Human Rights Commission and the committee, they've not also fared better. As a matter of fact, some of the critics of the system have described these bodies as toothless bulldogs, and they label as bodies that are not capable of holding African states accountable. Now, what are the factors? What are some of the factors? Of course, this is not an exhaustive. I will be answering some of your questions. The first one that stands above all actually is the lack of political will. Like we said, they ratify these treaties for different reasons. They want to be seen as compliant with human rights, so that when you say, "Oh, how are you doing there?" Say, "Oh, we have ratified this. We care about women's rights. We've ratified Maputo Protocol. We have ratified CEDAW." So they do all of these things just there, but then the political will is not actually there to do the things that their obligation require them to do. And one of the things that usually, implicates that affect the political will is the issue of sovereignty, which Prof. Hans has spoken about in the morning. States just want to protect their own space. And also, interestingly, research has also shown that there is a very interesting perception of some African states about the legitimacy of these bodies. So, and one example of that is the withdrawal of Rwanda from the Article 34.6 of the African Court Protocol. So, in that memorandum, Rwanda actually claimed that it's withdrawing. So, the Article 34.6 protocol, like I'm sure Prof. Hans mentioned in the morning, allow you to bring individual cases to the African court. Now, Rwanda claimed that it's withdrawing, that it doesn't want its citizens to go to that African court because it has now become a tool for the opposition. So now because some of the cases that the African court were deciding were taken by the opposition and political party, and of course, political issues, democratic issues, and human rights issues. So the court has to make a decision. Then Rwanda say, "Oh, you see, now we see that you're providing an outlet for these people." Then they label the court as a tool for the opposition, and then they decide to withdraw from the court protocol. Now, also, this one I'm putting here because it doesn't have to do with the African human rights bodies, because this is actually a decision of the United Nations Human Rights Committee. But this is closer to home. This is the only one case, as a matter of fact, that the International Human Rights Body has found South Africa to be in violation. And I remember when Advocate Zakula was speaking, she did mention the fact that there's a tendency for South African civil society organizations. And one of the indictments for that is that at the UN level, there's only 2 cases that have been decided against South Africa, which shows the extent with the fact that South African CSOs don't usually exploit these mechanisms, as you would expect. And at the level, there is none in which South Africa has been found to be in violation. Anyways, what happened in this case was that this case had gone to the Human Rights Committee, and when South Africa submitted its report to the Human Rights Committee, and the Human Rights Committee asked South Africa, "What did you do about this case?" And they said, "No, we did our best. These people, they just felt like we did not do enough, and they ran to Geneva." That was the exact word. So, in a sense, there is that absence of political will, because there's just that perception of you are giving people something that we are not giving them at the national level. And also, there is the idea of protecting, traditional cultural practices. So now I'm just using the concluding observation as well of the CEDAW Committee on Polygamy to South Africa. That's what I'm trying to say. And now I'm not debating, the legitimacy of polygamy or not. But the point is, in some of the concluding observation recommendations to South African polygamy, one of the defense of the South African delegates was that, look, not tell South African men to only marry one man. But this is difficult to say. I mean, like I said, I would leave that. You will decide if you think that is right or wrong.
And can you tell a South African woman to be involved?
No, that's why I'm not going into that. This one, you see, the illustration there is just to say that the states also say that, look, we cannot do these things because within our context, it's difficult. See, at the end of the day now, that concluding observation of the civil committee is not being implemented. That's why I say it is kind of like business. If that is correct or not, you will debate that. This next slide now. Now, the second issue, the second reason why implementation is also problematic is the fact that there is the involvement of different state actors at the national level with respect to implementation. So now, let's say the African Children's Committee. Now, when the African Children's Committee issues its concluding observation, it's probably the Department of Women that goes before that committee. But then, if with respect to stateless children, that is an immigration issue. So there is, and that involves the Department of Home Affairs. But the Department of Home Affairs is probably not the one that has gone to Marseille. Also, if they say, pass this law, now the executive, in terms of ratification of treaties and going to these bodies, it's the executive organ that does that, the department and all of that. But when you say change your law, that is not going to be done by the executive. It's going to be done by the legislature. Now, maybe the executive comes back and they really want that law to be changed, and then they take it to the parliament, but the EFF just doesn't like it. And now, there is that internal politics that is playing out. So you see, at the international level, it is just seen as South Africa has taken this conclusion observation because maybe the Department of Justice appeared before the Human Rights Committee and they've gone back home. But now, when it comes to implementation, there's EFF, there's ANC, there's the DA involved in that process. So, and also, this is the case in Ghana. It becomes worse, for example, when it also involves the judiciary. So, for example, this case of Weyeme versus Ghana, the Supreme Court of Ghana just said we are not changing our decision because we are the apex court and there is independence of the judiciary. So you cannot come back from wherever you've gone to, Geneva and all of that, and tell us we should do this and this because these people say that. And also, I mean, there's also a lot of debate that even our courts don't like to listen to international human rights bodies because you think that, like imagine the Constitutional Court of South Africa, the apex court has given its decision. And now you go to the African Commission on the same issue. And the commission say you need to reopen this case for retrial. Now the court will not be impressed because the court will think, wow, do those people in Banjul, do they understand the South African Constitution? So that is one. That is the second one. The next slide, please. I'm just going fast. So this one, I think I have a bit covered it because it's the lack of coordination at the national level. So when it falls within,
I don't understand. I'm just trying.
of course, he doesn't understand. He doesn't understand international rights. So now, I said even at the national level now, and even when it falls within an arm of government, the executive, for example, you see that these departments, they don't talk to each other. So the Department of International Relations, they get these concluding observations that say something about education, we should go to the Department of Education, that says something about immigration, then nobody does anything. And you ask someone, there's a concluding observation that says this and this from the Department of Immigration, and they're like, yeah, but we don't know anything about that. So in a sense, there's that absence of national coordination at the national level, and that effectively affects the implementation of the jurisprudence. So the next slide. So now, this one, I think there's been a lot about this, but it's the lack of support from relevant African human rights organs. Sorry, that should be African human rights organs, not bodies. And that goes back to the example that Advocate Lakula gave about how the African Commission issued observer status to cows, and then the AU Executive Council said they should, withdraw that observer status. So in a sense, the human rights organs that are supposed to, help this, so the AU organs now, that are supposed to help these bodies to implement and enforce their decisions. They don't play their role. As a matter of fact, they take steps to undermine those bodies. And the CAS situation is one example. Now, another example that I put here is the Article 31 of the African Court Protocol requires the court to submit report to the Executive Council and to list states that have not complied with the decisions of the court. So in a sense, they want to name and shame these states. Now in 2018, the Permanent Representative Committee now recommended that the Executive Council should actually tell the court to stop putting the names of African states that have not complied with this decision in its activity report. And even though Article 31 of that charter clearly provides for that, now at the political level, they ignored that binding obligation. And of course, they did what they have to do. And there was a lot of protest from the president of the African Court, but at the end of the day, that did not materialize. So now, that is also, some of the things. I think this should be the last in terms of the challenges. Now, what we have noticed, which then also now goes back to our role, is that there's also, even on the side of civil society organizations, there is inadequate engagement with the jurisprudence of the African human rights system. Now, I'll give you one very direct example. We about shadow report. Planning to submit shadow report here. Anyone? No? So when you leave this workshop, you are not planning to submit.
I mean, it is the hope now.
Not now, but yeah, working on it.
Alternative reports, complementary reports.
Yeah.
You had it, right?
Yeah.
Are you planning? Are you thinking about it?
Yes.
Okay. So how do you understand that process? I mean, after you submit the shadow report, what do you think?
From my recollection,
Okay.
it's that, well, first of all, the shadow report will be submitted by an organization that has observer status, right? So for those of us who don't at the moment, there's also different ways we can do that. Collaborating with organizations that already get the report and then send it through to the AU for consideration. The commission would read that report first before it engages with the state's report and use that as a reference point to some of the reporting that comes out of the state report.
Yeah, you don't need your thorough status really to do that.
Oh, okay.
You can still do that. But now the point is, you see, after you've done that, see, now there is the need for you to understand that it's a cyclical activity. You see, when you submit a shadow report and you say the government of South Africa is not doing ABCD, when the concluding examination comes out and it says the government of South Africa should do ABC. You see, what I found out in some of my research was I had some interviews with some civil society organizations, and then I told them, okay, you submitted this report, and the concluding examination that came out from that state report and from that reporting cycle was that South Africa should do this and this, which ties nicely into the issue that you have raised in your shadow report. Then I asked them, what did you do after? And they said, but are we supposed to do anything? Yeah.
Yeah, because if there's no mechanism created for engagement.
But they've already issued a concluding evaluation. Okay, Sabelo, you want to say something?
No. So my response would be that it can be used as a tool by which to lobby. It becomes an effective activist and optimist tool.
I was going to say exactly, similar, but use it as a measure to put pressure on to implement their recommendations.
Exactly. But you see, what you would think it's pretty straightforward, as they have said, like you would quickly think that if you do that, you will understand it that way. But what I found out was that most of the civil society organizations, they did not see it that way. So my understanding was this was a project that was funded. We have to submit a shadow report for the year 2022. That is part of the activities to be reported back to our donor. And then they do that, and that is the end of that period. They move on to the next thing. Whereas, like you have said, and she has said, that is a springboard for you to now build on that and say, okay, this and this and this and this, because it gives you, that freedom to do that. Can I see if I still have another statistic? Yes, I'll just quickly. That's it. Okay, so
Just one question.
okay,
Does the shadow report have to be negative?
negative. What does the word mean?
I'm just saying negative. Does it have to say that which they are not doing, or can it be that way?
No, so the purpose of the shadow report is two things: primarily to provide additional information, or to show what the state has said is not correct. So you can provide additional information. Let's say there are some burning issues. If the state has submitted a report on gender-based violence and stateless children, but you think that, accessibility for persons with disabilities is crucial and it's not in that report, and it's happening, you have an understanding of the national context. So your shadow report now can say, yes, South Africa has said this and this, but also there is this issue about accessibility for persons with disabilities. So in that instance, you are providing complementary additional information. Now, your shadow report can do a second job. Maybe the state say, oh, we give 5,000 rands to students every month, and the right to education, and all of that. But that's not true. Like I said, the state report comes out covering themselves in glory. So you, because you understand the national context, you know that this is not happening. Yes, it's on paper, but it's not happening in practice for X, Y, Z. Then your shadow report provides that information. So if what the state has done, if they've done it, there's no point. If you agree with that position, then there's nothing to shadow. There's nothing to compliment in that sense, because you're just saying yes, they've done it. It's not. It doesn't have any purpose in that sense.
So if I am to say yes, you've done it, but you could do better, or you could improve what this is.
That is when you provide additional information. Yes. So, anyways, so the slide stops here because I couldn't finish my slide because I was busy trying to do A, B, C, D. But really, I would just quickly from my laptop, good thing I have about 4 minutes more, just talk about briefly how civil society organization can improve the jurisprudence of African human rights body. So this concept is actually coming from the theory of domestic mobilization. And there's a favorite quote that I like very much by Beth Simmons. I'm just going to adopt it for our purposes. So now we will say the jurisprudence of the African can only become causally meaningful to the extent that they empower national actors, in this case now civil society organizations, that would otherwise have not been empowered to that extent to challenge the government. So like the example that you're giving, if you had gone to the government to say, oh, we think you should do this and this for minority groups in South Africa, they can say, yeah, but why should we care about Sabelo? What's our problem? But now, when you go and you write a shadow report or you lobby, let's say the African Commission, and the African Commission issues a concluding observation that says South Africa should do ABC as it relates to minority groups in South Africa. Now, what has that done for you? The next time we are going back, you are not going to say, I, Sabelo, think this. You would say, look, the African Commission issued this concluding observation and say this and this and this and this. So you see, to that extent, it has empowered you beyond where it raises your negotiating power. Now you're not going to say, oh, I am saying this. You are building on what the African human rights body have said. So that in a sense is what the theory of domestic mobilization is all about. And also, when you remember from the presentations in the morning by Victor, by France and everyone, there is a limitation to the extent to which the African human rights bodies can take steps by themselves to enforce these decisions, of course, for some of the reasons that I've spoken about. So now there is a big responsibility on us to now take on the mantle and take steps to ensure that these things also materialize. Now, what are some of the steps that we can take quickly? The first one is we can provide technical and capacity support for the African human rights bodies. So I'm just going to be using an example here and there just to say what I mean so that I can wrap this up in 5 minutes. So technical and capacity support, let's just go back to what Advocate Nakula said about how the Center for Human Rights, in conjunction with the Commission, worked on on passing the model law for access to information. So you see, in that sense, the center sort of supported the Commission by providing that technical and capacity support to help the Commission to realize that goal. Now, the second one is, we can also engage in dialogue with the relevant national actors. So as civil society organizations, when these outputs are made, you can engage with the responsible departments in the country to say, okay, look at this and this and this. These are the things that we want you to do. Then the third one is to raise awareness about the experience of African human rights bodies through our advocacy. You will be surprised that most of these things, even though it looks like in a particular part, it may look like there's a lot of knowledge about it. But then a lot of people are not aware about some of these things. So one good example of that is in our unit, for example, now, this year we started a project. It's on awareness raising on recent decisions of African human rights bodies. So what we just try to do is we pick a decision of the African human rights body. We actually did one on the European case. And I think you may find it interesting because I know you are sort of interested in indigenous people's rights. And so what we try to do is we try to raise awareness to say this thing has happened. And there was a lot of people attended from Kenya, from everywhere. So it gave people that knowledge that there is something out there for you to use, to mobilize on. And also the fourth one is, in a sense, we can also build some sort of strategic litigation and mobilization around some of the jurisprudence of the African human rights body. So, Davina said my time is up, and I will just stop here. I will complete my slide and I will share with you. Thank you very much.
Do you know what the compliance is with either the EU system or the Inter-American platform?
Okay. Okay.
On the issue of shadow reports, how guard against donor manipulation of the reports? I say this because there's an organization I worked for at some point, and the reports ended up now being tilted to present that would ensure donor funding as against being the reality on the ground. So how does one get to balance that in as far as the reporting is concerned? And at the same time, I would like you to talk to the issue of the African Commission and the Section 34.6 declaration, where the Commission is taking up a case on behalf of an individual or an entity who comes from a country that has not made the declaration. How does that work in as far as representation for that particular country and therefore the implementation of whatever ruling comes?
Okay. Chelsea, right?
Yes.
So I think your question is about the compliance status of the EU and the UN, just to see. So I see where you're going, just to see if they're faring better.
Yeah.
Actually, in the interest of time, I couldn't, go into some of this one. The UN system, as I told you that the AU system has been the AU bodies have been described as toothless bulldog, and the UN treaty system has been described as a system in crisis. So you see, that tells you your answer. So implementation, the crisis of implementation and compliance is not actually peculiar in all fairness now to the African human rights bodies alone. It it is everywhere. It's just that maybe I would say from my own personal experience, I would say the US system, in terms of its internal functioning, is a bit more predictable and has more stability than the AU system. But in terms of compliance, the result is almost the same across the board. I think it goes back to that issue of political will. Most of these treaties are just ratified by states to score some points, and then when it comes to the time to do these things, nobody wants to be held accountable, either at the UN, at the AU. The EU, it's a bit fairer because they have some sort of much more stricter political organ to implement some of these decisions. But overall, this scoreboard is not too different for all of these bodies. So now, to your question, the issue of shadow report and donor manipulation of the shadow report by trying to fit the content of the shadow report to what they want as regards to the reality on the ground. Well, I don't run an NGO, that is the executive director of the Center for Human Rights. But what I really think is, I don't think it's correct if the NGO knows what they're doing. I don't think the donor should be able to manipulate the content of your shadow report, because it is not the content of your shadow report that is actually within the control of that fund that you're receiving, if you really know what you're doing. I mean, if we receive funding from, let's say, Sapelosi Baghdad, that says we should submit shadow report, that's the description of the project, submission of shadow report in the African Commission. I will not take it from you to tell me that the content of my shadow report must be A, B, C, D, because otherwise, I'm not doing anything. Because I'm supposed to shadow what the state have submitted. I'm supposed to complement what the state have submitted, and I'm supposed to say things that the state did not say. So I think it's also from an ethical perspective and also understanding what you're doing. I think if a donor is going that far, it's okay for a donor, for example, to say, my funding is for this specific project. And to the extent that the donor has said, my funding is for shadow report, and I have agreed to prepare a shadow report, and I'm doing that, then I don't think the donor should have that control. I think if a donor is saying that, it just means the donor is doing that in bad faith, and it's just for the civil society organization to probably turn. I mean, maybe also we also have to understand that we don't have to take everything. Because just to say, this is also one of the things that African states have used to criticize the system. Yes. Because they come and say, we don't take these people seriously, because most of these things that they are saying are they're just instructions that they are receiving from the Western world and all of that. And this is definitely us proving them right. So I think my suggestion would be that, yes, now the executive director was
I would contradict everything he said. No, I can just say, I've been in that position for a number of years, and like Foluso say, you canvass, you tell people what to do. In all my experience, we've never been told by a donor what to say, but they support us, our work, building the capacity of civil society, of institutions, and so on. So I would also take the greatest exception if a donor would come and say that. But it's an important point, because this increasingly, from civil society as well, that you have these laws all around the continent that brand civil society as foreign agents, that take money from foreign. So it's important to push back on this. If we didn't have donor funding from the Scandinavian countries and open society, we would not exist as an NGO. We depend on those. But we work on our terms. And if we are prescribed what to do. So, I hope that that's where we all come from. And it's important to insist on that.
No, that's true, because you see, I experienced this with an organization I was working for, and I had to part ways with the organization because I refused. I was in charge of a particular project under that organization, and they're telling me that this is what you need to put down. The donor wants to see this, the donor wants to see that. I actually, at some point, went to Geneva, to the UNHCR, with a mandate as to what I should say when I get there. And I went there and I said what I was responsible for within my project, and we ended up parting ways.
Okay, I'll get the detail from you privately.
I understand that, because they both have NGOs. Can I just take the last question?
Do we have more questions?
I think mine will be maybe a comment. I don't know if it's really addressed to you, but maybe you will answer it.
Or the director can just answer.
Okay. This human right the African human rights bodies you spoke about. And you spoke about the shadow reports which civil society organization can submit to challenge what the government have submitted. So I wonder, are we able to use the same African human rights bodies to challenge the AU itself? And my question is, okay, we have, let me say, we have the AU Agenda 2020, where it was said that they will silence the gun in the continent. and up to date, the gun are still alive in the Tigray region. And how are we holding the AU itself accountable? Can we like bodies to challenge them? We have also the AU Agenda 2063. All people write this agenda, by then they will be dead. How are we going to hold accountable? And which mechanism are we going to use? Thank you.
Well, so I'm going to start, but you see, there's a professor of international human rights law here. That's why I'm trusted doctoral student. But if, the jurisprudence of the African Court, just the recent decision in the case of the Western Sahrawi, is anything to go by, I think my answer would be that, unfortunately, at the moment, the answer to that is a no. That's your
And I just wanted to repeat that case name.
Okay. So it's what is the title of that case? I will look for it and send to you. But it's against it's about the Western Sahrawi and against the admission of Morocco into the AU, which I think Dr. France also said something about in the morning. But anyways, the court did not the court did not entertain that decision. But the jurisprudence, the jurisprudence of the court, I mean, I read it, I wasn't super convinced. But what I see that the court was trying to say, that it did not say in explicit terms, is that you cannot sort of sue the AU as an institution. I mean, the court gave a lot of very confused, but it was trying to be a bit diplomatic. That's my interpretation of that decision. They did not say it that way because that would be a court admitting to be a bit restrictive in its interpretation of the Constitutive Act. But the bottom line is, it would appear that the answer for now is no. Also remember what Victor was saying in the morning about the African Court of Justice and that it's supposed to be established when the 15 ratifications have been made. I think if that court ever comes into existence, then that would be a court that will most likely be able to take up that type of cases. Of course, maybe the implementation will come out fine or not. It's a different question. I think, yes, I would say, that is what I would say. I prefer
I just think that, perhaps we should also be a bit modest. The AU is a big architecture. There's the human rights architecture, which is in a sense technical. It's about experts adjudicating and saying what these rights commitments mean and holding states accountable. But these are broader political questions, right? And there's a Peace and Security Council, there's the peer review mechanism, the African peer review mechanism, there is the Pan-African Parliament. So other institutions also provide spaces. I'm not saying that they necessarily provide the solutions, but I don't think to put the big political questions on the shoulders. I mean, the African Commission has not been put there to resolve the issue of Western Sahara and Morocco. It could lead to a human rights violation and there should be a finding, but the ultimate resolution is not going to go through a human rights body, right? Because I think it's a broad political question. Just to say, I think we have to look at the system in totality and choose which avenue is best to be used to explore as well. It doesn't mean that the human rights framework is less important, but it is existing in a context, in a broader context.
So I think I have gone past my time. Okay, thank you very much, everyone.
So now we're going to have breakaway session. We will have 3 groups, right, Ryan? Okay. So okay. I'm going to count 1, 2, 3, and then all the 1 will move here, 2's here, and 3 there. Is it fine? 1, 2, 3. Remember your number, please, because I will forget.
They must just
One.
say it.
Okay, 1. So you are.
That's a fresh.
Okay, all right.
Wait, 1, 2.
3. 1.
Two.
3.
2.
1.
3. 1. 2.
1.
2. Okay, all right. So all the one, please move in front here.
Maybe, so we have 30 minutes allotted to that particular activity. I think if we can spend less, the better for all of us. And I was also thinking, because of the power outbreak, we may be very constrained in here. And
Go outside.
I feel like
Yeah.
we could move a little bit outside. So one group, fortunately, may be able to retain the space here. Then another one outside there, and another, the third, where we had breakfast from. 10 minutes. Oh, 10, 20. 30 minutes. Okay. So, but what are we doing with the,
Yeah,
the,
but
the
make
breakout
sure that
session?
you here.
So during the breakout sessions, each of the groups, so if you're number 1, you look for where the ones are. If you're number 2, you go to where the
Should I
twos
go
are.
out or stay?
And if you're number 3, you go to where the threes
You
are.
have to see
Number
where
1
your
will
group
be
is
here.
going. You are on
Number
number.
2's out there. Number
Okay.
3 is where I had the breakfast from. So you're going to, in the group discussion,
Yeah.
identify an issue from amongst yourselves, from the different backgrounds that you come. Highlight one issue. Of course, you can present a number, but then agree to that one issue that you think, based on the knowledge you have acquired today, you can consider for to be pursued before any of those bodies. And of course, that means what solution are you looking for, depending on the issue. Is it something concerning children? Is it something that you want to pursue through the African Commission or through the court? So yes, the issue, the possible solution that you think you want to consider, and number 3, the platform or court, commission, committee that you want to go to. 30 minutes. The 3's, where we had breakfast from, number 2's outside there, and number 1 here. I wish you good luck.
Did you all get the
Go to 2.
what you wanted to write?
Go to 2 now. Right?
Yes. Number 1 is identify the issue. Number 2, what is your proposed solution? Number 2 is the proposed solution. And number 3, where you want to go to seek that solution, because we know that it is the 3 bodies that we have been discussing today. So the number 1s are staying here. Okay. So I'm Aaron Justin.
Yeah.
So you're number 1.
I was number 2.
Number 2. And you are exchange.
Because he needs to say
You want to swap your number.
Yeah.
Perfect.
number 2 is going on.
So number 2s we have that corner. And number 3 is where we had breakfast from.
So the number 2 is, yep. Number 1, yeah. Yeah. So what's presentation?
So what will happen at the end is that we shall then have a session for presentation of our different issues and solutions for then assessing. We have a panel that's going to be assessing how we have appreciated these aspects of the training.
Okay.
So I think the proposal is just to convene together and so you select a secretary and perhaps the person who will be making the presentation.
Number one, yes.
No, five. One, two. So who's the secretary?
Everyone is looking at me because
The paper one.
We are promoting gender emancipation.
Well, the delegate here is well dressed in a suit.
And she will present.
If somebody can
Yeah, that's absolutely. That's,
yeah?
you guys are just
If we occupy all the posts, we can say no gender,
gender,
No.
so we try to address gender equality.
The gender imbalance.
I feel like my rights is being affected. Are you also
Yes. So much chair, and the secretary must change.
Yeah, well, since you're the secretary, I think you
Okay.
unless if there's someone who feels
Now you have to work as name is Donna, it's just fallen off. So the first question we need to tackle is the common issue that we can agree on.
over children?
Children. Oh, okay.
Oh,
With an issue.
I think our biggest issue right now is drugs for children and how tradition plays a role in them.
Can you repeat yourself?
Drugs
Okay.
and how tradition plays a role in them. So, for instance, a child, obviously, drugs is a no-no, and then if he is, for instance, a Rastafarian, a parent will say, oh, at school.
cannabis is a drug for kids.
Towards rights that Rastafarians is supposed to smoke.
So you're classifying it as a drug.
Is it an issue, so to say?
So my advice is, I'm not going to interfere anymore. You want to look at something where the regional system has a comparative advantage, right? We can do many things about many problems here where we are. Today now we think,
Yeah.
how can, this dimension. So it's good to put the issue on the table and then think, how can the regional system, maybe it's you can put a number of issues and think, where can the regional system, the commission, the court and all that, how can it benefit?
Yeah.
Sounds right? Sounds right.
Okay, let's put issues first. Eh?
Let's put issues.
Yeah, then I need to also add the issue of xenophobic violence.
Okay.
And the reason why I want to put it on there is that I feel, let me say, speak for myself, that the systems within South Africa, they failed to address the issue of xenophobic violence. And the reason is that we never had, since 2008 to date, even one instigator remaining behind bars. So I feel that local systems, they failed to address those kind of